Vermont is one of the most tenant-protective states in the country, and its approach to rent increases reflects that philosophy. While Vermont doesn't have traditional statewide rent control that caps the dollar amount of increases, the state has enacted specific notice requirements and procedural protections that give tenants meaningful safeguards, and recent legislative activity has pushed the state even further in the tenant protection direction. The governing law is found in Vermont Statutes Title IX, Chapter 137, the Residential Rental Agreements Act. Let's start with the notice requirement, because Vermont has one of the longer rent increase notice periods in the nation. For all residential tenancies, Vermont requires the landlord to provide at least 60 days written notice before a rent increase takes effect. Under Section 4455A, the landlord must deliver written notice to the tenant at least 60 days before the effective date of the increase. This applies to month-to-month tenancies, and it also applies at the renewal of fixed-term leases. 60 days is twice the 30-day standard used by most states and gives Vermont tenants substantial time to evaluate the increase, adjust their budgets, or begin searching for alternative housing if the new rent is beyond their means. The notice must be in writing, must clearly state the amount of the current rent, the amount of the new rent, and the effective date of the increase. The notice should be delivered by a method that creates a verifiable record, personal delivery, certified mail, or other documented methods. For fixed-term leases, the rent is locked in for the duration of the lease term unless the lease includes a provision allowing midterm increases. At the time of renewal, the landlord must provide the 60-day notice of any proposed rent increase. Because Vermont also requires 60 days notice for non-renewal of a lease, the timing of renewal communications is critical. The landlord needs to decide and communicate the new rent well in advance of the lease expiration. Here's where things get more complex. Vermont's just cause eviction protections interact directly with rent increases. As we covered in our Vermont lease termination video, Vermont landlords cannot terminate a tenancy without a legally recognized reason. This means that a landlord cannot use a massive rent increase as a tool to force a tenant out. If a landlord raises rent to an amount clearly above market rate with the apparent intention of making the tenant leave, rather than reflecting a genuine market adjustment, the tenant could potentially challenge the increase as a constructive eviction or as a violation of the spirit of Vermont's tenant protection framework. Vermont courts have shown willingness to scrutinize landlord conduct that appears designed to circumvent tenant protections, and a rent increase that serves no legitimate business purpose other than to drive a tenant out could face judicial pushback. This doesn't mean landlords can't raise rent to market levels. They absolutely can. But the increase should be justifiable based on market conditions, operating costs, or property improvements rather than appearing to be a pretext for eviction. Now, let's talk about Burlington, Vermont's largest city, because Burlington has gone significantly further than state law in regulating rent increases. Burlington enacted a ballot measure that established a rent stabilization program, making it one of the first cities in New England to implement rent control in decades. Under Burlington's ordinance, annual rent increases for covered units are capped at a percentage tied to the Consumer Price Index, and landlords must comply with specific registration and notice requirements. Burlington's rent stabilization program includes provisions for landlords to petition for increases above the cap in certain circumstances, such as when operating costs have increased substantially or when the landlord has made significant capital improvements. The program is administered by a local board that reviews petitions and evaluates whether the proposed increase is justified. If you own rental property in Burlington, you must comply with both the state's 60-day notice requirement and Burlington's rent stabilization cap. The more restrictive rule applies in any given situation, so Burlington landlords need to understand both layers of regulation. Other Vermont municipalities have been considering their own rent stabilization measures, and the state legislature has debated various proposals to implement broader rent protections statewide. The political trajectory in Vermont is clearly moving toward more regulation of rent increases, and landlords should stay informed about legislative developments at both the state and local level. Rent increases cannot be retaliatory. Vermont has strong anti-retaliation protections under Section 4465 that prohibit landlords from raising rent in retaliation for a tenant exercising any legal right. Protected activities include making a good faith complaint about habitability to the landlord or a government agency, filing a complaint with a housing authority, participating in a tenants organization, testifying in any proceedings related to the landlord's obligations, and exercising any right under the Residential Rental Agreements Act. Vermont's anti-retaliation provision is particularly robust. If a landlord takes adverse action, including a rent increase, within a specified period after the tenant's protected activity, there is a presumption of retaliation. The burden shifts to the landlord to prove by clear and convincing evidence that the increase was motivated by legitimate business reasons. Clear and convincing evidence is a higher standard than the preponderance of the evidence standard used in most civil matters, which means Vermont landlords need very strong documentation to overcome the presumption. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and Vermont's own Fair Housing and Public Accommodations Act, found in Title IX, Chapter 139, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, sexual orientation, gender identity, disability, familial status, age, marital status, or receipt of public assistance. Vermont's protections are broader than the Federal Fair Housing Act. The inclusion of sexual orientation, gender identity, age, marital status, and receipt of public assistance gives Vermont tenants additional protections. The receipt of public assistance protection is particularly significant for rent increase purposes. A landlord cannot raise rent specifically to push out a tenant who receives Section 8 vouchers, reach-up benefits, or other government assistance. If a rent increase appears targeted at subsidy recipients while other tenants in comparable units are not similarly affected, the landlord could face a fair housing complaint. The Vermont Human Rights Commission investigates fair housing complaints and can take enforcement action, including ordering damages, injunctive relief, and civil penalties. A discriminatory rent increase can result in significant liability for the landlord. From a practical standpoint, Vermont's rental market is shaped by the state's small population, limited housing supply, and high demand in certain areas. Burlington, the state's largest city with a metropolitan population of around 200,000, has the tightest rental market in the state, driven by the University of Vermont, the medical center, and a growing technology sector. Rents in Burlington are substantially higher than in the rest of the state, and the new rent stabilization program directly affects how landlords can price their units. Montpelier, the state capital, and its surrounding communities have a smaller but competitive rental market. Resort communities, particularly those near major ski areas like Stowe, Killington, and Sugarbush, have unique rental dynamics driven by seasonal tourism. Rents in resort areas can be significantly higher during peak seasons, and landlords may use seasonal pricing strategies. However, Vermont's landlord-tenant protections apply to all residential tenancies regardless of location, so seasonal landlords must still comply with the 60-day notice requirement and other statutory obligations. Rural Vermont has a different dynamic. In many smaller communities, the rental market is less competitive, and large rent increases can result in vacancies because tenants have alternatives. Vermont's aging population and the outmigration of younger residents from some rural areas means that rental demand can be soft in certain parts of the state. Landlords in these areas need to balance revenue goals against the reality that aggressive pricing may lead to extended vacancies. One best practice for Vermont landlords: plan your rent increases well in advance to accommodate the 60-day notice requirement. If you want an increase to take effect at the beginning of a new lease term or at a specific date, count backward 60 days and add a buffer for delivery time. Missing the 60-day window means the increase cannot take effect on your planned date, which can cost you revenue. Another best practice: communicate rent increases in the context of the value you're providing. Vermont tenants are generally well informed about their rights and are more likely to accept a rent increase that comes with an explanation of what the increase covers: rising property taxes, insurance premiums, maintenance costs, or property improvements. A brief, professional explanation accompanying the notice isn't legally required, but it builds goodwill and reduces resistance. For landlords with properties in Burlington, compliance with the Rent Stabilization Program requires ongoing attention. You must register your rental units, track allowable increase percentages, file required documentation with the city, and understand the petition process for increases above the cap. Working with a local property management professional or attorney who is familiar with Burlington's specific requirements is advisable. Vermont also has specific rules about security deposits that interact with rent increases. Under Section 4461, the security deposit cannot exceed the lesser of 2 months' rent or the actual anticipated damages. If a rent increase pushes the proportional deposit above this cap, the landlord should be aware of the limitation. However, Vermont does not require landlords to adjust the existing deposit amount when rent increases. The cap applies to the amount collected at the beginning of the tenancy. For the complete guide to Vermont rent increase laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel so you stay current on every state's requirements.